Right, good morning everybody. Nice warm day. I have taken my jacket off. If anyone else wants to remove jackets, please feel free to do so. I think it's allowed in the summer, particularly when it's as muggy as it is today. Right, I've got a couple of announcements before we start the meeting properly. First of all, I'll read out, I would like to remind everyone present that this meeting will be broadcast live on the internet and will be available for repeated viewing for 12 months. If you are seated in this room, you are deemed to be consenting to being filmed, and any contributions to the meeting will be recorded and broadcast. And then we've got another notification here. Again, good morning, and can I please express our apologies on having to postpone the meeting on the 16th of June. Fortunately, we've been able to secure today's date to hear the reports. However, I need to advise members and the public that due to this week being Staffordshire Armed Forces Week celebrations, we are expected to end today's meeting at 11:30 due to room requirements. I stress that any items that are unable to be heard today will be deferred. I apologise for any inconvenience that this may cause. Now, as chairman, I have asked that those deferments are dealt with as soon as possible, and it may possibly mean we have an extra meeting, a special meeting to cover them. But that's the situation we're in. We will finish at 11:30 to vacate the room for Staffordshire Armed Forces Week. Okay, and we go on to the agenda properly. We'll start with apologies.
I've got apologies from Councillor Hudson, Councillor Pritchard and Councillor Waring.
Thank you. No other apologies? No. We'll move on to declarations of interest. No. Now, if we do get to the item number, bear with me, the Fortin one. What number is the Fortin one? Item number 7. I will have to declare that I am the local member for Nosal and Doxey that covers Fortin. No, Fortin, not important. It is the heat. Okay, right. So we'll move on to. Did you get my declaration? Yeah. Move on. No other declarations. No. Move on to item number 3. Move it. Okay. Okay. Thank you for that. And number 4, item number 4, we've got review of the definitive map modification order service, and Heather's going to give us a report on that. Thank you, Heather.
Okay, good morning, Chair, members. This report sets out recommendations following a review of the definitive map modification order service, which has recently been carried out by officers. As members will be aware, the Council as Surveying Authority has a duty to maintain a definitive map of public rights of way within its administrative area. Where any person has evidence to suggest that the definitive map is inaccurate or incomplete, they can submit an application under Section 53 of the Wildlife and Countryside Act 1981, requesting a modification. This process is known as the definitive map modification order process. The process is very labour-intensive and time-consuming, with several different stages, each of which involves a significant amount of officer time being invested, and the Council currently has a backlog of 290 undetermined definitive map modification order applications. The legislation provides that if an application has not been determined after 12 months of being accepted by the Council, the applicant may apply to the Secretary of State for a direction. and if granted, this will require the Council to determine the application within a specific time frame, which is typically between 6 and 12 months. The Council currently has 68 outstanding applications on which it has been directed. There's a table on page 3 of the report which sets out how many applications have been received by the Council, the number of directions received, and the number of directed applications determined since 2017. As members can see, the Council has during that time been directed to deal with a total of 166 applications within a specific time frame within the last 6 years. This has resulted in a distorted list of applications whereby many of those on which the county has been directed are relatively new applications, which means that those older applications where no direction has been received are not being dealt with ahead of applications which are much newer, much older, and in many cases, other than the direction, there doesn't appear to be any reason why those cases should be prioritised over older cases, which are currently much further down the list of undetermined applications. Although the number of directions received per year is falling, the Council still has a significant number of undetermined directed applications. Officers have recently carried out a review of the service to try to identify ways of reducing the backlog more quickly within the current staffing and experience levels, work practices, policies and procedures. As part of this review, 15 other local authorities were surveyed and responses received were from 12 of those authorities. Many have similar backlogs as set out in the table at the end of page 4, beginning of page 5, although none of those authorities have been directed to determine as many applications as Staffordshire has. The reason for that is not clear from the information provided. Unfortunately, the information collected from the survey didn't present any specific measures or solutions which the Council could use, which would have a significant impact on Staffordshire's backlog. The majority of the authorities who responded also had a significant backlog of applications and faced similar challenges. However, officers have reviewed the current processes and did identify some measures which would help reduce officer time spent on certain stages of the process. The first one being an increased use of delegated powers, thereby allowing determinations to be made between panel dates and also reducing the preparation time for panel, allowing members to focus more on the more contentious cases. The second measure is to consider whether an application could be determined by other means, such as a diversion or public path creation agreement. This may only have minimal impact, as many of these applications are contentious and landowners are often opposed to public rights of way across their land. However, where it is a viable option, an application can be progressed without the need to wait until it reaches the requisite ranking in the definitive map modification order backlog, thereby resolving the case much more quickly. The third measure is that the council is also looking at digital solutions to reduce the amount of office time spent sending out application packs and preparing and sending out reports for informal consultation, thereby reducing paperwork and officer time spent on administration. More work is required on the latter two solutions, and this is ongoing. However, the intention is to implement the increased use of delegated powers with immediate effect. Referring back to the survey, what that did show is that many of the authorities surveyed had priority statements in place. These differed between authorities, but there were some common themes which tended to accord with their council's policy objectives, such as improving connectivity and promoting active travel. As a consequence, the council has also reviewed its own priority criteria and has set out a new priority scheme, which is set out at Appendix B of the report. Which, if approved, will replace the current priority criteria, which is set out as Appendix A. A scoring matrix is currently being developed and tested for the new scheme, and the intention is, if approved, to implement the new scheme later this calendar year once the scoring matrix is in place. The intention is to try to bring forward applications to which certain circumstances apply, either by application of owners of land affected by the application, or where officers identify that it would be beneficial to prioritise a particular application for a variety of reasons as set out in the new scheme. Turning to the new scheme, this is in 3 parts. Firstly, those on which the county has been directed by the Secretary of State, as we currently prioritise. The second part allows owners and occupiers of land to apply based on one or more of the circumstances set out in B to E of the new scheme. And the third part sets out circumstances at F to I, which would be at the council's discretion, and this discretion is intended to be delegated to the Director for Corporate Services, and if members approve the new priority scheme, the delegation will be considered by the next Audit and Standards Committee, which is on the 11th of July. Officers recommend that the panel approve the new priority scheme as set out in Appendix B and also support the proposed measures set out in paragraph 27, which are intended to reduce officer time spent on the process. Thank you, Chair.
Thank you. David?
Chairman, I'm perfectly happy with the report. We've got to do something that reduces the backlog that we've got. There's only one element that I am concerned about. We are a legal panel making legal decisions, and we know from what's recently happened the consequences of that decision being challenged. I was very uncomfortable about the fact that we hadn't got a full attendance of the panel making decisions on things that we were doing. It makes me feel even more uncomfortable if we find that those have been decided by officer delegation. And I just wonder whether I don't feel as a member of this panel that it's fair to place legal decisions of this type onto officers. And I just wonder whether we might have been able to work with the officers to be able to meet more regularly, to be able to rapidly deal with those issues. Thank you, Chairman.
Paul?
Thank you, Chair. I agree with David, but another matter I disagree with. Excellent report, so thank you very much for the report. However, it's Appendix B, Item 2, C, Item B. Detriment to health. How do we judge what's happened to somebody's health? Anything else in law, I don't know where. Let's say the Crown Court backlog now, we've got perhaps a 3-year backlog. So if somebody says, I've got a bad back, or I've got this, I've got that, they don't jump up the list. And I just think, everything else in that appendix, I agree with. But I really think health should be taken out. It's too open a topic. Does somebody come in and say, well, my mother's got dementia, or whatever it is? I just think, I can't vote for it while health is in there, I'm sorry.
Okay, can I just, before I bring you in, Heather, I think the point you've made, David, about delegated decisions, I understand what you're saying, but we do already have a large number of delegated decisions which are quasi-legal, so or are legal decisions, and I think it's something that officers should be aware of. But I'm fairly relaxed as long as we've got the protocols are right, that we take that as part of it. In terms of members, today proves we have got a lot more work coming in, which is good, because we want to get through the backlog, and anything that can help with that backlog, it's not just it can't just be through the members, has got to be good for the residents who've brought these matters to us. Heather, you've had two there. What are your views on them?
I'd like to address both of those, if I may. With regard to the delegated powers, we do actually already have delegated powers which are delegated to senior management in legal services. And the intention is only to use those delegated powers in respect of non-contentious applications. So anything that is contentious, which frankly is probably the majority of them, the intention is still to bring those to the Countryside Rights of Way panel as we currently do. So I'm not sure what impact it would really have on the amount of decisions that would be brought. So at the moment, it is only non-contentious applications that we would be intending to decide on by delegated powers.
I'm content with that, providing there's absolute clarity that they are non-contentious applications, and that if there's anything which is marginal, it comes to committee.
If we look at our parents' committee, the planning committee, the majority work done at the planning committee is done by deferred decision to officers. So we're just really going along what they do there anyway. So if we had to look at every planning case that came in, the full planning committee, we'd have a backlog like this, wouldn't we really? So I have to agree that we may need to defer non-contentious matters, a greater number of those.
Okay, and Heather, could you mention the health issue?
Yes, I will, Chair. Could I just make one more comment about the delegated as well? The other criteria with regard to our delegated powers is that the local member has to agree that it can be determined in that way. So we would always have to consult the local member in any event. So hopefully that would help with that particular issue. With regard to the health, we would be requiring them to provide evidence of any detriment to health. So it's really a question of judgment at that point. That would be a decision for the Countryside and Rights of Way panel. We would bring a report, and it would have to be obviously a confidential report. But we would require it to be supported by evidence, such as a doctor's certificate or something like that, depending on the circumstances.
I must say I echo the concerns from Councillor Snape on this one. It's almost such a wide sphere of concern health. It could be anything, as has been said, from a mental health issue to whatever. In the training, I'm not sure that we actually mentioned health. Could you please, and I think it is important, just put aside, it doesn't have to be War and Peace, just a quick word about it to all the members of the panel, so that we know what it is, or at the next meeting, please give us it might be better, a quick run through of what you mean by health, because as I say, when we did the training, I can't remember health being particularly mentioned. Now, if it's going to come more to the forefront, we as a panel need to know what we're dealing with. I don't know whether members agree with that. Yeah.
I mean, my reservation's slightly lessened when I know it's still going to come to us to decide if we do it. But if we could just have a top and a bottom where we make that cut off, what feels the criteria and what doesn't, I'd feel a lot better.
Yes, I can do that for the next panel. Okay, thank you.
Are you okay with that, David?
Yeah, I mean, I'm happy to move the recommendations, but I wonder whether we might have added into the recommendation non-contentious, because in the request here that we have, it could effectively apply to any application. I know that the intention isn't to do that, but we ought to say in the recommendation that we are agreeing delegated powers on non-contentious applications.
Heather?
The report isn't asking you to agree delegated powers because we already have those. So that's information, if you like. It's just for you to just to note. Really, it's the delegated powers are already in place. And what's in the delegation is that we have to agree with the local member and the Director for Economy, Infrastructure and Skills before we make a delegated decision, and that it is for non-contentious matters. So those delegated powers are already in place.
I mean, as long as it's clear that it is non-contentious, I would have thought as well it would have been useful to have referred them to you as chairman to have looked at.
I think the very fact that this is a minuted meeting and there's been a statement saying that it will only be non-contentious issues, and anything else, or anything, all of those should go through the local member and should go through the head of economic.
It's the Director of Economy, Infrastructure and Skills.
Yeah, so we are covered on that, and I'm happy. I think we'll now move on, please, to item number 5, which is the Delegation of Surveying Authority Functions Update. All right, apologies, I'm ahead of myself. Are we happy to approve the review of the map modification order service?
Yes. I'm happy to approve with the suggestions that have come from Heather, that what we've agreed this morning, basically, then I'll gladly approve.
Jack? Yeah, so it's unanimous on that one. Sorry, we move on to item number 5. Laura.
Thank you, Chair, members. This report is in connection with a cross-county footpath application received under Section 53 of the Wildlife and Countryside Act 1981. The proposed footpath would form a continuation route in the parish of Stapen Hill in Staffordshire and the parish of Bretby in Derbyshire. In addition to this cross-county boundary application, the panel are also being asked to approve updates to the scheme of delegation in relation to Section 53 applications. Turning to the cross-county application, officers seek the panel's authority to enter into an agreement with Derbyshire County Council under Section 101 of the Local Government Act 1972. Section 101 of the Local Government Act allows the discharge of functions from one local authority to another. In this case, we would delegate our powers to Derbyshire County Council for them to determine both of the Section 53 applications which have been submitted to both authorities for the addition of a public footpath, which would form one continuous route along the Staffordshire-Derbyshire county borders. So just a brief background, a Section 53 application has been made to Staffordshire County Council under the Wildlife and Countryside Act 1981 for the addition of a public footpath from Violet Lane, Stapen Hill, along the county boundary into the Bretby parish. The application is based on user evidence, and Derbyshire County Council have also received an application in connection with the same route with the same user evidence. In order to avoid any anomalies that may arise if one authority were to determine an application before the other, Staffordshire County Council are seeking to delegate our powers to Derbyshire County Council to determine both applications. Derbyshire County Council have agreed, in principle, to accept this delegation and will also request formal authority via their committee. Turning to the approval of the updates to the scheme of delegation, we are seeking approval from the panel to update the scheme of delegation in relation to Section 53 applications. This would allow Staffordshire County Council to delegate our powers to the appropriate neighbouring council in the case of any future cross-boundary applications, as and when such action would prove beneficial. Finally, we are seeking approval from panel to support the proposed deletion of the word properly from the Director for Corporate Services existing delegation in relation to Section 53 applications under the Wildlife and Countryside Act 1981, and there's further details of that in the report. Thank you. I'm happy to take any questions.
Paul?
It's not a question of it's common sense, really. I mean, okay, they might do it before us, but one of us might turn it down, the other accept it, so there'd be a right anomaly there. So I will propose that we go along with this, unless anybody else wishes to say anything first.
David?
I'm happy that we go along with it, providing the proceedings are open and clear for the public to view, that it's filmed so that people can access the proceedings in Derbyshire, and that there's every opportunity for people to be able to view what's going on and to understand the applications process. I don't know from our systems point of view, and perhaps we could take advice on this, whether it's possible on our broadcast system to be able to take something from another local authority so that we can actually view it on our Crow Panel site. I don't know what the situation is there.
If it were to be delegated to Derbyshire County Council, it would go through their procedures, and unfortunately I don't know at this current stage what their procedures are with regards to Crow Panel and determination. So that would have to be looked into further. But obviously they would have to seek authority to deal with both applications on behalf of Staffordshire and Derbyshire as well.
Okay.
I mean, I'm happy, Chairman, to move the recommendation with that qualification that we must be seen to be clear and open in what we do, and I hope somebody will find that out with Derbyshire about whether we're able to actually transmit that.
I think, if I could intervene as chair, we're delegating this to Derbyshire, so the comms around it and the public side of it, we delegate as well to Derbyshire. So I think it's Derbyshire's job to make sure that this is made public. It's not a problem, but obviously when people used to walk footpaths, they didn't know in the future it would be Staffordshire and Derbyshire and crossing backwards and forwards. So we will have cases like this, and it makes infinite sense. We've got the recommendations in front of us. I'm not going to read them all out because it's a side of A4. But the recommendations are A, B, C and D on page 17. Are we happy to take it forward? We've had a proposal from David, seconded from Paul. Okay? Okay. Right, thank you, Laura. And we'll move now, please, to an S53 application for upgrading public footpath 60 at Waterhouses, and it's Laura again, please.
Thank you, Chair, members. This is an application to upgrade public footpath 60 in the parish of Waterhouses to a restricted byway. The application has both historical and user evidence in support. I can confirm that we have received no objections or representations from the local member. I will move straight to the recommendation, which is that the evidence contained within the report is insufficient to conclude that a restricted byway subsists on the balance of probabilities. The initial application submitted in 2018 was supported by historical evidence, with further historical and user evidence submitted following initial consultation. The historical evidence submitted includes the Parish Survey Card, Cauldron Tithe Map, Finance Act Map 1910, Ordnance Survey Map 1897, and the 1929 Handover Map and Schedule. Supporting documentation was also submitted in the form of photographs, a National Library of Scotland map, an e-petition, a public inspectorate decision, and a letter from the Staffordshire County Council Department for the Education dated the 2nd of November 1979, which are all appended to the report. The 1951 Parish Survey Card and Map shows footpath 60 and 60A Waterhouses as RP. This is the acronym used for a road used as a public path. The Parish Survey Map accompanying the card shows the acronym CRF. The description for the acronym CRF and CRB are not dissimilar to the description of a RUP, as both definitions refer to ways that could be used by vehicles but were mainly used as footpaths or bridleways. Officers will consider that if the route had higher status, the acronym CRB would have been used instead of CRF, denoting the routes used predominantly as a footpath. Even with these classifications, the types of right over the route were not easily identifiable. The notation could be a descriptive term for the path's appearance rather than any reference to any rights enjoyed over the path. This classification was addressed in the 1968 Countryside Act, which stated that all RUPs should be reclassified to footpaths, bridleways, or a new category, byway open to all traffic. The County Council prepared its first definitive map in 1969. It would appear at the time of this review the alleged route was deemed to be a footpath, and no evidence has been put forward that this classification was objected to. As a result of the Hugg case, 1975, it was understood that the routes classified as RUPs would not be reclassified as having public rights lower than a bridleway. However, the case of Trevelyan showed that the contention that a reclassified RUP would support evidence of actual bridle rights is on its own insufficient. The fact that the way was previously shown as a RUP does not mean that the route should automatically be upgraded, and therefore all evidence needs to be evaluated to determine the exact nature of any rights over the route. The Cauldron Tithe Map of 1836 shows the route running along the line of footpath 60, and this is numbered 48. The award book accompanying the Tithe Map describes the use of this route as a road. Routes shown separate from land holdings were likely to have higher status than a footpath or a bridleway, although these could be public or private. It is unclear if section 48 refers to the entirety of the route, as there appears to be a line across the way which could indicate an ownership change along the route. The definition of road can include footpaths as well as vehicular routes, and therefore the status cannot be inferred with any certainty from this evidence. The Finance Act Map 1910 shows the route uncoloured and unnumbered and separate from land holdings. This could be suggestive that the route was a public highway. However, private routes over which multiple parties have private access rights were also excluded from the valuation as well. The fact that the route is shown separate from adjacent land could have been excluded as there was no landowner and it was a private right-of-way. The Ordnance Survey Map 1897 shows the physical existence of the route. The map key accompanying the alleged route in question is recorded as a third-class road. The purpose of Ordnance Survey maps was to show physical features on the ground, but they do not distinguish between public or private rights of way. Handover maps are a result of the 1929 Local Government Act, transferring responsibility for publicly maintainable highways from rural district councils to county councils. They were internal documents and were not subject to any consultation process. The field book and maps were only concerned with maintenance and not the type of user, and therefore they don't prove any particular rights or status, as both roads and footpaths in the past were publicly maintainable. Again, this document supports the route's physical existence as a public right-of-way, as it shows a liability for the way, but it does not accept into the nature of the public rights, and therefore does not provide any conclusive evidence to support that the route was a restricted byway. What is not an issue here is whether the route is public, as the route is already an existing public footpath. The issue is the nature of the rights over the route. So turning to the user evidence that has been submitted, this is from 8 users and members of the public claiming to have used the route as a restricted byway. The evidence ranges from 1992 to 2003. A user matrix can be found at Appendix O of the report. Section 31 of the Highways Act 1980 sets out the test that must be satisfied under statute for a way to become a highway through usage by the public. For the application to be successful based on user evidence, it will have to be shown that the public have used the alleged route as of right and without interruption prior to the status of the route being brought into question, or that it can be inferred by the landowner's conduct that they had dedicated the route as a public right-of-way and that right has been accepted by the public. In this instance, there does not appear to be any challenge to the use of the route, and therefore the date of application is taken as the date of challenge, being 2018. Therefore, the relevant 20-year period is 1998 to 2018. From the evidence submitted, only 3 of the users have used the path for the relevant 20-year period. The remaining 5 user evidence forms are for lesser periods of time or do not fall within the relevant period of use. 2 of these users are minors, and therefore their use would have been unlikely to have been independently and as of right. It could be argued that the level of use as a restricted byway would not have been enough to bring it home to a landowner's attention that they were present. The remaining part of the Section 31 test considers whether the landowner has undertaken any action to rebut the statutory presumption of dedication. In this case, there does not appear to be any evidence that the landowner has taken steps to show an intention not to dedicate the route as a restricted byway. The evidence also needs to be considered under common law. However, only 3 of the users have used the route for more than 20 years, and the number of users who claim to have used the route as a restricted byway is too low to have brought it home to a landowner that a right was being asserted across their land. On circulation of the initial report, the applicant objected to the recommendation and was given the opportunity to provide further evidence in support. Further historical and user evidence was submitted. The applicant disagreed with officers' interpretation regarding the path symbol shown on the parish survey card. However, officers contend that the route has been considered, if the route had been considered to be a bridleway, the acronym CRB would have been used instead of CRF. The applicant also disagreed with officers' interpretation of the Finance Act map and referenced guidance from the Planning Inspectorate guidelines. However, officers would contend that it could have been shown as excluded as there was no owner and that it was a private right-of-way. The report has been rewritten following an examination of all of the evidence submitted. However, officers' recommendation remains unchanged. The council have received no response from any adjoining landholders. The parish council has no objections to the application, and the Byways and Bridleways group support the application. So to conclude, it is officers' opinion that the user evidence submitted is not sufficient to meet the legal tests, as there is insufficient evidence to show that the route has been used uninterrupted for 20 years, or that the landowner has dedicated the route as a restricted byway. It is also considered that the historical evidence is not strong enough to support, on the balance of probabilities, that the alleged route has restricted byway rights over it. Therefore, it is officer's opinion that the evidence is insufficient and the route should remain on the definitive mapping statement as a public footpath. Thank you. I'm happy to take any questions.
Have we any questions? Jack?
I'd just like to thank officers for the report. It was very substantial. I was just looking at page 67, where there's the photos where it shows us more than a footpath. It looks far more substantial than that, but due to the weight of evidence and your report, I'm very happy to accept it. Thank you.
I think the numbers involved, as it says in the report, it's weak if it's under 6, strong evidence if it's over that. Looking really at items 157, 158, the reasons behind it, it's also the fact that you've got the people who would have been 3 and 4 at the time saying that they were unaccompanied, etc. I go along with your report basically saying that on the balance of probabilities, while it is a right of way, it's not, I'm trying to use your legal terms. Yes, a public footpath, not right of way, and nothing to the contrary has been proved to the balance of probabilities. So I will propose, well, I will second Jack's that we go along with office recommendation and we reject the application.
Okay. We've had a proposed seconder. All those in favour? That's unanimous. Laura, thank you for that presentation. We'll move forwards now to, and we are swapping about on the agenda because of the time limits, on to item number 7, which is the Wildlife and Countryside Act item 8, sorry, Wildlife and Countryside Act application for an alleged wood footpath from Wadden Lane to the A518, the old A518 Western. I have been approached by one of the landowners who was concerned about the safety of the route, and I made no comment on that. And I think this is the Laura show again. Would you like to give your presentation, please?
Thank you, Chair, members. So this is an application for the addition of a public footpath from the old A518 to Wadden Lane in the parish of Weston. The line of the route can be found at Appendix B to the report. I can confirm that we've received no objections or representations from the local member. Moving to the recommendation, which is that the evidence submitted by the applicant is sufficient to show that a public footpath is reasonably alleged to subsist along the route at Appendix B, and that an order should be made to add the alleged right-of-way to the definitive mapping statement for the Borough of Stafford. The application has been submitted on the following historical evidence: a deposited railway plan of 1845, the 1847 Western Tithe Map, Ordnance Survey Map 1836 to 1840, a Yates's map dated 1775 and 1798, a Carey map dated 1806 and 1982, Greenwood map dated 1820, a Teesdale map dated 1831 and 1832, and a Wright and Carrington motoring, cycling and touring map. The 1845 deposited railway plan shows a plot that is separate from adjacent land holdings and marked with the number 10. The book of reference for this plot refers to the plot as a parish road to Gayton. The owner is recorded as a surveyor of highways and Richard Wilcox. This would suggest that the plot was considered to be public, as the surveyor would not have wanted to take on unwanted maintenance responsibilities. The narrative supports that a historical route of some description existed leading off the A518 in a northeasterly direction. Although the route is not shown in its entirety, it is shown as the same line as the claimed route in question. The Western Tithe map shows the physical existence of the alleged route on the ground, which is shown separate from adjacent land holdings, and it's coloured sienna, which is the same colour as the other roads in the area. The route is unnumbered, which is supportive evidence that it was indeed part of the connecting highway. In this case, the entire length of the alleged route is coloured the same as other routes and is shown separate from adjoining taxable land holdings. This suggests that the land was not in production, and whilst the status of such rights are not conclusive, it is suggestive that a public right-of-way of some description existed over the alleged route. The lack of a transcript associated with the plan does not distract from the evidence, and it is clear that the route is linked to other routes in the local area. The claimed route leads to Gayton in the north. This annotation of a way leading towards a named settlement or place is also suggestive of public rights. The Ordnance Survey map dated 1836 indicates a through route along the line of the claimed route, and whilst unable to provide any evidence as to the status of the route in question, Ordnance Survey maps do provide evidence of the physical existence of the route. The various old maps submitted with the application appear to show the physical existence of a route in a similar location to that of the claimed route. However, there is nothing from these maps to indicate the status of the route or the nature of any rights over it. Upon circulation of the report, the landowner responded to the report and indicated that there was no access through the boundary hedge from Wadden Lane onto the land. The comments can be found at Appendix G of the report. The landowner believes that there is no material evidence that a footpath has ever existed over the proposed route and objects to the application. The landowner also provided additional comments on the amended report and recommendation, which have been provided to members as an addendum, highlighting the wildlife and safety concerns along the claimed route. However, as members will be aware, any comments in relation to wildlife, conservation and health and safety must be disregarded under the law as it currently stands. These concerns are not a matter for this tribunal of fact and must be disregarded. If the application were to be successful, then our colleagues in Rights of Way would be able to advise on how these concerns might be mitigated. So moving to the legal test, the application is made under section 53(3)(c)(1) of the Wildlife and Countryside Act 1981, and therefore there are two tests to be considered. That of the balance of probabilities, whether the route subsists, or reasonable allegation, whether it can be reasonably alleged that the route subsists. In conclusion, the probity of the evidence from the deposited railway plan and the reference to the Surveyor of Highways and the tithe map provides strong evidence that the alleged route is a public right-of-way. There is no evidence to suggest any evidence of higher rights along the route. Therefore, it can be reasonably alleged that a public right-of-way exists with the status of public footpath along the route shown as A to B on the map attached at Appendix B. The width of the route should be 1 metre, the standard minimum width for a crossfield footpath. Thank you. I'm happy to take any questions.
David.
Can I just clarify something that you said about the landowner is saying that there is no evidence of access onto a public footpath? I know that's not evidence that says that there shouldn't be one, but what happens if we approve it today? Does the landowner have to provide access, or do we just wait people to go and knock the hedge down?
So if you made the recommendation that you believe that the public footpath was there historically, then our Rights of Way team would go out and assess the situation there. The fact that it's fallen into disuse, that's a matter for our colleagues in Rights of Way to go and look at the proposed footpath.
So we create an access?
That's correct, yes.
I'll go along with Officer's recommendation and ask that it be added to the definitive map. Once a footpath, always a footpath. The fact that it's perhaps fallen to disrepute. Applicants are asking me that we bring it back into use, and so I'll go along with recommendation and propose it.
I'll second that, Chairman.
Thank you. Because I have been approached by the landowner, and it's almost a personal interest, I'll defer from voting on this. Yeah, we've got a unanimous vote for the rest of you. So thank you, Laura. That item's been passed. And we'll move on, if you'll correct me if I'm wrong, item 10, which is the S53 application for an alleged public footpath from the A51 to the B5404 in the parish of Swinfen and Packington and Wigington and Hopwas, sorry. And I understand this is Becky, please. Would you give your report?
Morning, Chair and members. I'll just tell you that this report was actually prepared by Steph Clarkson, but she wasn't able to be here today, so I'm doing my best and reading it out for her. So, this application for a public footpath between the A51 and Hopwas House Farm. The application was submitted by Mr. Martin Ray, and the route of the claimed path is marked A to B at Appendix B of the report. In support of the application, Mr. Ray included a copy of an enclosure map, a transcript from the award from 1771, an OS map of 1834, a map drafted by Greenwood in 1820, and a map drafted by Teesdale dated 1832. Other documentary evidence was sought, and 4 users completed evidence forms stating that they had used the route. The evidence was analysed, and the enclosure map was believed to be conclusive of the route along Packington Lane. This was supported by the other evidence provided from Mr. Ray. The user evidence was considered, but was insufficient to establish that users had created the route as of right. 5 landowners were ascertained to have ownership over the length of the lane. This evidence is found at Appendix E. Landowner 1 and 3 did not consider the route to be public, and landowner 2 was unsure as to the status. Landowner 4 did not consider it public, but informed the council through their solicitors that if the recommendation was to accept to add the route, they would be requesting a diversion around a farmyard. The correspondence relating to this can be found at Addendum 3, together with the 5th landowner's evidence form. The report was sent out on the 12th of January 2023. Extensions of time were provided for the landowners to provide additional evidence. Following the issuing of the report, landowner 1 provided substantive documentation refuting the claim, which can be found at Addendum 1 and 2. With this application, there are 2 separate legal tests to each claimed path, one of which must be satisfied before a modification order can be made. The first test is whether the evidence on the balance of probabilities shows the right of way does subsist. The second test is whether the evidence shows that a public right of way can be reasonably alleged to subsist. On consideration of the evidence, the weight of the Enclosure Act and the subsequent award are substantive of the existence of the route in its own right, which is supported by a little further, albeit weak, evidence. It is your officer's opinion that the application for the route between points A and B passed the test of being reasonably alleged to subsist under Section 53 3CI of the Wildlife and Countryside Act 1981. Your officer's recommendation, therefore, is that the footpath does subsist. Happy to take questions. Thank you.
As there's no questions, I'll just go along with the officer's report. The evidence submitted by the applicant is Appendix A, and that discovered by SCC is sufficient to show a public footpath not shown on the definitive map can be reasonably alleged to subsist along the route A to B on the Appendix B, and that the order should be made. If they then, after we've made the order, if we go along with that, then it's up to us perhaps to tell them if they want to have a diversion. It's their right to apply it, but the fact that they need a diversion is not a reason why we turn it down today. So I'll propose it.
David.
Chairman, just to clarify, we have a procedure, I believe, where we have the need to divert a footpath round a property, that we delay implementing the approval to give them time to put in their application to divert it round the farmhouse. Am I correct about that?
take that, Chair, if I may. No, what the panel has to decide is whether or not the route exists in law as it is. If the landowner wishes to divert, then they will have to put an application in to divert at a later date.
I appreciate that, Chairman. I thought we had a procedure where we've got something which could theoretically be contentious, where it's going very close. I seem to recall one that we had which went through a farmyard, and we had an application to divert, and we delayed approval of the application to allow us to consider the diversion.
If we don't approve it, they don't need diversion. So to apply for diversion, we've got to make the application first to say the path exists, then they can apply for our diversion. Because if we turn it down, then the diversion is not needed in the first place. So it's bureaucratic idiocy to do it that way, sorry.
Again, I think if we refer back to the training we've had, the fact that a landowner will probably need to divert doesn't deter from any decisions we make here. We make the decision whether it's a footpath, a byway, bridleway or whatever, and then it's up to the landowner, as Councillor Snape said, to put an application in to divert it, which will be heard with clarity when it comes forwards. But no, it's not my understanding that we do defer anything.
Chairman, I understand the procedure and that we need to approve or reject it. I just thought that we had something within the system. Obviously, I'm mistaken, but I thought that we had a way of accommodating a landowner where an application could be contentious.
No, is the simple answer. Am I correct, Heather?
I think if a landowner agrees that it's a public right-of-way, then it really depends on where it is in the process. If they want to apply for a diversion much earlier in the process by accepting that it's a right-of-way, then we can accept that, provided that we're not at a point where we're going to be bringing it to panel in any event. But we are expecting, but the landowner would have to accept that it's a public right-of-way, and we would have to put that burden on them if that makes sense. So it's a question of the landowner. It's up to the landowner, really. I think is what I'm saying there. We can't force the landowner to do that if they don't accept it, which I'm not sure whether that's the case in this particular instance. They don't accept it's public, so we can't. We will have to make a decision, and then it will have to go through the process. And
Chairman, I completely accept that. If the landowner is going to accept it, then he needs to get his application in to divert it as quickly as he possibly can. And presumably that would be dealt with under officers' delegated powers. It wouldn't have to go into the sausage machine and wait 10 years for consideration.
No, the diversion route is very different process. So no, it wouldn't go to the back of the list. But it's a question of whether or not the landowner actually accepts that it is a public route, because if they don't, which I understand is the case here, then they may not wish to apply for a diversion under those circumstances. They may wish for the process to go through the whole of the process till the end, which it could be that they appeal the decision, object to the order, which means that there could be a public inquiry which will determine whether or not it actually is what we're currently making an order for or recommending to make an order for. If that does go through that full process, then the landowner still has the option of diverting it before it, at that point. Actually, it will go on the definitive map at that point, but they still have the option of diverting it. But it doesn't alter the status of the route, because if it is determined that it's a public right-of-way of whatever status, it already exists in law in any event. We're not adding anything new. We're adding something that already exists, which is why we would have to which is why the landowner would have to actually accept it to be able to divert it.
Chairman, I'm perfectly happy to go with the officer's recommendation. I hope if the landowner's watching this webcast that he understands what the process is and takes the advice that he's had from this committee to deal with his problem. Thank you, Chairman.
Thank you, David. So I'll take it because of the form, the proposal from Councillor Snape, seconded from David Smith. Yeah, unanimous.
Could I just say that now we've agreed it, that if the if the objector does agree that it's a genuine right away, not going to appeal, that we do deal with it as quick as we can in any diversion, really, just to hopefully put the objector's mind at rest that it is going to happen, subject to appeal, of course, at a later stage. But if they decide not to appeal, go along with it, that we do deal with that side as quickly as possible.
Okay, thank you. And this is an interesting one because we move from the country to the town. And this is item number 11, which is the, am I correct on that one? The S53 application for addition of a public footpath from Corporation Street to Jail Square. And that's David. Welcome.
Thank you, Mr. Chairman, members of the panel. And I can confirm that we've had no representations or objections from the local member. I will move straight to the recommendation, which is that the officers feel there is sufficient evidence on the balance of probabilities that the route subsists and should therefore be added to the definitive map and statement for the Borough of Stafford. This turned out to be a somewhat complicated application and had been submitted by the applicant, Mr. Martin Ray, in 1997. As members will see, this is a lengthy report with lengthy objections, and your officer's exposition of these objections has been equally in depth. Turning to the matter in hand, we have an application for the addition of a public footpath between Corporation Street and Jail Square, Stafford. This was an application based solely on user evidence, and a total of 47 forms were submitted, and these can be seen in Appendix C. The complex nature of this application is due to the fact that the alleged route crossed land owned by Staffordshire Health Authority and its successors in title, namely the Midland Partnership NHS Foundation Trust. This fact is pertinent to the application in that a claim under statute is not possible due to Crown immunity affecting the land during all or part of the relevant period. The matter must therefore succeed or fail on the common law test. It is also important to note that a significant amount of development has taken place on the land in question, with a new housing estate being built in close proximity to the alleged route. As such, a myriad of additional landowners has come to light since this application was made. Putting all of this to one side for a moment and turning to the evidence, we find that we have a 20-year significant period running from 1977 to 1997, with an overall range running from 1947 one user to 1997 multiple users. We will use the term significant period rather than relevant period to distinguish it from the statutory test. You will see a detailed breakdown of the individual user evidence between points 32 and 70 of the report, although the key facts to note here are that a significant number of people were using the route throughout a significant period of time, and that this use was as of right. This as of right use is evidenced in the witness statements, as there was no evidence of force, secrecy or permission, nec vi, nec clam, nec precaria, and there was a predilection for using the route on foot. The frequency of use also carries probity, and you will see a breakdown of this at point 36 of the report. Some users were accessing the route on a daily basis, easily sufficient to bring its use to the attention of the landowner. There is also an incredible amount of consistency throughout the user evidence, both with regard to the route itself and the ways in which people were using it. We have consistency in the line of the route, consistency in the reasons for use, and even consistency in the frequency of use. Clearly, there has been open use of the route for 20 years, and critically, this has been without interruption. There are only incidental references to obstructions or challenges along the route, and where these did exist, they were unreferenced, anecdotal, without date or questionable one-off occurrences. As such, their probity is limited, and of the very few references we have, not one would constitute a valid challenge. For example, reference was made in one of the forms to an unnamed person who had been told not to use the route by another unnamed person and at an unknown date. Clearly, if the unknown person had submitted a signed witness statement of their own, highlighting this with a location, date and name of the person challenging use, then it may have carried more weight. These points are important as this particular matter has to succeed or fail on the common law test. The land in question benefited from Crown immunity in the past, which means that any rights of way cannot, in this case at least, be claimed under statute, and that the only possible means is under common law. For clarity, we do not have the full 20-year relevant period necessary for under statute due to the period of Crown immunity. As members will see at point 61 of the report, various bodies are protected in this way, including the Crown itself, the Duchies of Lancaster and Cornwall, and certain government departments. They are protected from claims under statute, but are not protected from claims under common law. There are, Mr Chairman, similarities between the statutory test and the common law test, although for the latter there is no set time frame and no relevant period within which to weigh the evidence. Indeed, the courts have taken as little as 18 months to be sufficient to prove a way subsists under common law. Notwithstanding, your officers had already identified a relevant 20-year period that would have been sufficient to prove the matter under statute, and as such this period was retained for the common law test. Officers accept that under common law the dedication by the landowner is as important as that dedication being accepted by the user. The owner also has to have the capacity to dedicate the route. From the evidence, it would appear that for at least 20 years there was no evidence of the landowner's non-intention to dedicate the route. Again, there was no evidence of signage, no evidence of challenge, and no evidence of obstruction. There were no permissions and no statutory declarations lodged by any successive landowner to protect against any new rights being created by user. The use was, as of right, with good frequency and for a sufficient period of time. Turning to the question of the landowner as a public body, having the capacity to dedicate a route, we note the Trust's objection on this point. However, officers maintain that a public body can, in general, create a right-of-way, provided that that public use would not be incompatible with the purpose of that body. This is referenced in the Cranage case of 2019, and I have a reference there, which members can probably see, where the inspector ruled in favour of the existence of the route, a public footpath, in a similar case to the instant one that involved Crown immunity, hospital land, public bodies and the common law test. Although in that case the appeal was allowed under reasonable allegation at common law, rather than in this case on the balance of probabilities. Turning to the landowner's submissions at the time of the application, we find a paucity of evidence between points 160 and 166 of the report, much of which refers to the possibility of dedicating a route through the new housing development, although this was not pursued by any party at the time and as such has little relevance to the matter in hand. That said, if members were minded to accept the application, then any decision may indeed be subject to a subsequent diversion order, either in full or in part, due to the said development of the land. However, this is not a matter for this tribunal of fact. Turning to the landowner representations received following the circulation of the draft report, members will again see the lengthy submissions from the Trust and your officer's exposition of each of the given points at Addendum 1 and 2 of the application pack. Although detailed submissions, the objections raised are not material to the claim and nothing turns on them. None of the other landowners made any representation or objection. In summation of what has been an incredibly complex case, your officers feel that there is indeed sufficient evidence to show that the alleged route subsists on the balance of probabilities and that the lower test of reasonable allegation is also inevitably satisfied. It is therefore your officer's recommendation that the application be accepted and the route added to the definitive map and statement for the Borough of Stafford with the status of a public footpath. Your officers further recommend that the minimum width should be 1.8 metres throughout its length, a width commensurate with the existing character of the new developed land. Thank you, Mr Chairman. I'm happy to take any questions.
Thank you, David. Just 2 points from me. First of all, it's quite interesting that Councillor Snape earlier in the meeting mentioned health, and this is the Health Trust turning down a footpath, or trying to get a footpath application turned down. That's my first point, which is sort of slightly erroneous. But the other point is that the minimum width on this is 1.8 metres. And in the previous report, it was 1.5 metres. How do we sort of decide what width these footpaths should be? I thought there was a set formula.
Yes, thank you, Mr Chairman. There is a set formula. It's legally the minimum width is 1.5 metres for paths of this nature. Although many years ago, and we think it was in Leicestershire, nobody really knows, the 1.8 metre width sort of arose. and has been used consistently in many applications throughout the years and since that time. In this case, because it's through a very built-up area, officers felt that a 1.8 metre, which is 3 extra inches, would benefit the route in question. It's unusual for officers to make that decision, but in this case, I think it would be pertinent to the claim.
Thank you. And any thoughts from members? No? Okay. Would anyone like to propose this? Yep.
Could I just clarify again, what's the current condition of the footpath? I mean, is it usable and in regular use? Well, you've talked about usage, but I'm talking about as of today.
Yeah, yes, thank you. It varies along the length of the route. At one end, we have access. There are pavements that have been built over houses that have been built over front gardens that sort of encroach onto the claim line. So it is very variable along the length. One end, the eastern end, is quite open and it would be accessible, as is the far west end. But the bits in between, we've got this development and the issues of the new properties. So that would need to be taken into account with our rights of way section if members were minded to accept the application.
Would you ever propose that?
I'll propose it. I love it when a report contains one of Lord Denning's cases. I mean, to me, perhaps one of the greatest legal minds of the last century. And he talks about the challenge in that, where there's no barrier put up. And for the 20-year period there was no challenge. So why that's been put in, I don't know, but it's in the objection to it, really. I'll go with officer's recommendation. And as with the last one, there's going to have to be diversions, perhaps more than one diversion because of the building on it. But we've had the 20-year period. So no challenge, it's consistent that it's been used. Okay, the numbers are low and what they've been put in, but I will propose that we go with officer recommendation.
Seconded by Jack. Are those in favour? Okay, unanimous. Thank you, David, for that report. We're still on track for 11:30 finish. So we'll move back to item number 7, which is the application for an addition of a public bridleway between the A518 and public bridleways 8 and 28 in Forton. Not important, although it is important to me. Forton Parish. It is part of my county area, so I will abstain from voting on this one. But have the report is coming forwards from Laura again. Thank you, Laura.
Thank you, Chair, members. So this is an application to add a public bridleway between the A519 and public bridleways 8 and 28 in the parish of Forton. I can confirm that we received no objections or representations from the local
Laura, sorry, apologies.
Sorry.
Before we go any further, I've just been advised by my advisor that David will have to chair this item if it's in my area. So just for the record, I'm stepping away from this one. And you can stay and listen to the... Yeah.
Thank you. So I'll move straight to the recommendation, which is that the evidence contained within the report is insufficient to conclude that a public right-of-way can be reasonably alleged to subsist. The application at Appendix A is based on historical evidence. The applicant submitted a tracing taken from the plan of the Newport branch of the Birmingham and Liverpool Junction Canal, which is dated 1826, together with a copy of the extract from the Book of Reference. These are at Appendix C to the report. The deposited canal plan, dated 1826, shows a plot in the Forton parish just south of Sutton parish. The claim plot is shown and numbered 33 on the plan. The Book of Reference accompanying the plan records plot 33 is owned by the Surveyor of Highways. This may be considered convincing evidence of a public right of some description. However, the primary purpose of deposited canal plans was not to record rights of way, and the weight to be given to this can only be determined when it's considered alongside all the other evidence available. It can be alleged that canal maps and their associated book of reference not always differentiate between public and private roads. The applicant also submitted a 1-inch to 1 mile ordnance survey map dated 1834. The alleged route appears to leave the main carriageway. However, the map is not suggestive that the route links to another highway or place of interest at its most southerly point. It merely comes to an end. In the case of Folkestone Corporation versus Brockman 1914, if a way leads from one recognised highway to another, or from one inhabited settlement to another, the inference may be relatively easy to draw. If, on the other hand, it leads nowhere, the inference may be more difficult to draw. On examination of the Ordnance Survey maps dated between 1891 and 1925, the maps do support the physical existence of a route, but do not provide any evidence as to whether these routes over it were public or private, or the nature of any such rights. Again, these maps do not support the contention that the route linked to the main highway at its most northerly point. The alleged route would appear to be named on the 1891 Ordnance Survey map Shipley Lane and Sheepley Lane on the maps dated in the 1900s. Whilst the naming of a lane on the Ordnance Survey map carries some inference of public status, it does not in itself give the lane any indication of the nature of the rights over the route or the status, and is therefore not persuasive evidence of a public right-of-way. Ordnance Survey maps have been considered by the court as being solely limited as evidence of whether there was a visible feature on the ground. Officers also examined the 1836 Fortin Tithe map as part of their investigation. The map would appear to show the alleged route as separate from adjacent land holdings and numbered 540. Plot 540 is named lane adjoining plot 474. Plot 474 has a recorded use of a meadow, and therefore is suggestive that the lane was used for access to neighbouring land and not a place of interest. The tithe map also suggests, as do the Ordnance Survey maps, that at the most northern end of the alleged route, where the proposed claimed route joins the main carriageway, the route ends in plot 492, which is named Stone Quarry, and this prevents the alleged route linking with the main carriageway. There is no evidence on the tithe map to suggest that Route 540 connects with the main highway at either end. The evidence submitted by the applicant and that discovered by the council fails to indicate that the route connected at a highway at either end. Evidence would suggest that Bridleways 8 and 28 Fortin, which the claimed route now joins at its most southerly point, only appear on the Ordnance Survey maps after the 1900s. The landowner evidence form appended to the report at Appendix G indicates that the alleged track to the northern end of the claimed route is a recent creation and it did not exist at the time of the sale of the land in 1977. Officers have received no additional comments from landowners, the applicant or the parish council in relation to the report. So the relevant legal test for this application is section 53 3C1 of the Wildlife and Countryside Act 1981. And this section relates to the discovery of evidence of two separate events, that a right-of-way which is not shown on the map subsists, or evidence that a right-of-way which is not shown on the map is reasonably alleged to subsist. In this instance, your officers consider that the evidence is insufficient to satisfy the test when considered on the balance of probabilities. With regards to the second part of the relevant test, whether the route can be alleged to subsist, your officers consider that this test would not be satisfied. With the discrepancies in terms of the route linking to a highway at either end, it cannot be established from the evidence provided where the route began and terminated. This in particular does not support the contention that the route was a public right-of-way. Officers consider that the evidence is insufficient to conclude that the route subsists or can be reasonably alleged to subsist, and therefore is not sufficient to satisfy the relevant legal tests. Thank you. I'm happy to take any questions.
Not questions, just really a statement. I mean, the last one I mentioned Denning, and this one, going back to 77, signs were put up saying it wasn't a route as well. So they were challenging it even then. So I will propose that we go with officer's recommendation and we don't add this to the definitive map. For the reasons all given by the officer.
Well, the recommendation is that the order should not be made to add the alleged route shown marked A to B on the map marked Appendix B to the definitive map. the statement public rights of way for the parish of Forton. So we're all agreed. Back to you, Chairman.
Thank you very much for that, David. And we'll move on to the last item we've managed to squeeze in, which is item number 8, the S53 Wildlife and Countryside Act. Sorry, I haven't crossed through that one. Item 9, the S53 application for an alleged public footpath between Deep Hay and Crown Point, Cheddleton. And I understand this one for you again, Becky.
Thank you, Chair. Yep. Back to me again. This report was drafted by Hannah, and I'm presenting for her today. So this application for the addition of a public footpath between Deep Hay and Crown Point in the parish of Cheddleton. The route has been split into 2 sections, and the line of the routes can be seen at Appendix B and are marked A to B and C to D. The application is submitted based on user evidence. In 1987, representations were made by Cheddleton Historical and Archaeological Society to SCC for the inclusion of the alleged route onto the definitive map and statement. This was supported with user evidence forms from 19 members of the public claiming to have used the alleged route. In April 1989, the council wrote to Cheddleton Historical and Archaeological Society advising that since they submitted their evidence, the council had started to operate the provisions of the Wildlife and Countryside Act 1981 relating to public rights of way, and therefore asking them to submit a formal application under Section 53 of the Wildlife and Countryside Act 1981 to request the County Council make a modification order to include the path on the definitive map. A further 11 user forms were submitted by Cheddleton Historical and Archaeological Society in 1989. The 3 members of the public who had submitted user evidence forms in 1987 submitted further forms. A formal DMMO application was submitted on the 22nd of June 1990 by Cheddleton Parish Council. All those who provided statements had also done so previously in 1987 and or in 1989. Some people who had previously provided statements in 1987 or 1989 did not do so as part of the formal application. Further statements were obtained from some of the users who had provided statements in 1990 in 1998. So we move on to the user evidence and legal test. In order to prove the existence of a public right-of-way under statute, Section 31 of the HA 1980 has to be considered. This is whether it can be known as the public have used the alleged route as of right without interruption for a period of at least 20 years prior to the status of the route being brought into question, and whether the landowner took any actions to prevent the statutory presumption of dedication, i.e. by locking a gate or erecting a notice. If we look at common law, the evidence will also need to be considered on a common law. Therefore, the applicant will need to show that the landowner dedicated the route to the public as a public right-of-way, and this was accepted by the public. The date route brought into question. In this case, there does not appear to have been a challenge to use of the route. Therefore, the date of the DMMO application has been taken as the date of challenge. Therefore, the relevant 20-year period is from 1970 to 1990. So, summary of the user evidence. 9 of the 20 users claim to have used the route marked A to B on the map, but not C to D. 3 of the 20 users claim to have used the entirety of the alleged route, including from points A to B and C to D. None of the users have over 20 years usage that covers the relevant 20-year period. 2 of the users have used the route for 15 years within the relevant timescale, and when their use is added together, this makes the relevant 20-year period. Another 2 users' evidence can be added together to make another user. The frequency of use is sporadic, with 4 users claiming to have used the alleged route once or twice a year, and the remaining users have either not specified how often they have used the route, or the level of use could be best termed as occasional. The landowner evidence. So Staffordshire County Council was identified as a landowner affected by the application route. They responded to the application advising that the section of the route marked C to D could not have been a public path as the route accessed a reservoir and access to the reservoir was not available to the general public. The reservoir ceased to function in 1980. Notices were in place at Wall Grange advising that the land was private. Staffordshire County Council also advised that during the period of 1972 to 1980, the Stoke-on-Trent Youth and Community Sailing Club was based at this location and access was denied at all times without the consent of the Commodore, who arranged appropriate persons to gain access. Landowner 2 and 3 advised that they were tenants of land affected by the application route and they had never given anyone permission to use the route. Landowner 4 advised that they had never given any permission to use the route, but equally they had never taken any steps to prevent members of the public accessing the route. So the response from the statutory consultees, Leek Ramblers Group responded to the application advising that some of their members remembered walking the path approximately 40 years ago, which would have been in the 1950s. Staffsmoreland District Council responded to the application advising that the path would be a valuable amenity function to linking the Deep Hayes Country Park with nearby countryside and the residential area of Cheddleton. So the analysis of the user evidence, the route marked A to B. 9 users showed that through their evidence that they had used the route marked A to B. The number of users and the level of use is low, and therefore it is unlikely that this use would have been sufficient to bring home to the landowner that a right was being asserted across the land. There is no evidence that action was taken by any landowner to prevent members of the public from accessing the route. However, this may be because the level of use was so low that the landowner was not aware of the use and therefore did not feel it was necessary to take any action. There is some indication that permission had been granted to members of the public, giving them permission to use the route. One user has claimed that a previous landowner gave them permission to use the route in approximately 1978. Also, several users refer to using the alleged route as part of the sponsored walk, which would imply that permission was given for members of the public to use the alleged route. However, it is unclear as to when the sponsored walk took place or that the majority of users were using the route through permission. The route marked C to D, only 3 users claim to have used this section of the route. There is evidence that this part of the route was a private right-of-way. The County Council have advised that this was a route used to access the reservoir and was not encouraged by the Water Authority to be used by the public. It appears that this was a route solely to provide access for those needing to use the reservoir and members of the Fishing and Sailing Club, and not for the general public. They further state that private land signs were in situ. However, none of the users have mentioned seeing private signs in this location. However, use for this part of the route is small, and it is likely that the signs were only in place when the reservoir was in use prior to 1980. On review of the conveyancing documents, it appears that there is an agreement in place between Staffordshire Brickworks and Staffordshire Water Board since 1960, which allowed access to the reservoir for both parties. The documents were supportive that until at least 1980, there were private rights along part of the route. The Parish Council further comments. Cheddleton Parish Council have been critical of the County Council in the length of time it has taken to determine the application following its submission, and in particular have raised concerns about the difficulty with clarifying evidence submitted by users following the report being drafted due to the length of time since users provided their original evidence. There are also of the opinion that the relevant 20-year period should be from 1967 to 1987, taking into account the first user evidence forms that were dated 1987. Officers used the date of application 1990 as there was no obvious evidence of a challenge to use of the route, and as made clear by section 31(7)(b) of the Highways Act 1980, ultimately the evidence and the level of use is still relatively low and sporadic. The legal test. The application is made under section 53 3C1. Therefore, the relevant legal tests are whether the evidence shows the route exists based on the balance of probabilities, or it can be reasonably alleged that the route subsists. To summarise, in relation to the section of the route marked A to B, the level and frequency of use is insufficient to show the route's existence, either on the balance of probabilities or that it can be reasonably alleged to exist. In relation to the section of the route marked C to D, again, the level and frequency of use is insufficient. Also, there is evidence that during part of the relevant period of use, access to this section of the route was private and not open to the wider public. Therefore, the evidence of use for this section is insufficient to show the route's existence, either on the balance of probabilities or that it can be reasonably alleged to exist. So in conclusion, it is the officer's recommendation that the evidence submitted is insufficient to show that either on the balance of probabilities or reasonable allegation, the alleged route at either points A to B or C to D exist, and therefore it is the officer's recommendation that an order should not be made to add the alleged route from points A to B and C to D to the definitive map.
Thank you for reading the report out. Quite a definitive report. David?
Chairman, I was only going to comment on the points that we've made about people being given permission to use the routes, that doesn't create a public footpath, and therefore I'm happy to move the officer's recommendation.
Seconder? Jack? All in favour? Okay, we'll go with the officer's recommendation on that one. We've still got a fair amount of time before 11:30, so I'm going to take an executive decision and do the final item, please, which is item number 12, which is the S53 application for a public bridleway from Birdsley Farm to Portway Lane, Wigington, and that's, I understand, is David. Thank you.
Yes, thank you, Mr. Chairman, members of the panel. And I can confirm that there have been no objections or representations from the local member. I'll move straight to the recommendation, which is that your officers feel there is sufficient evidence to reasonably allege that the route subsists and should therefore be added to the definitive map and statement for the district of Lichfield. This was a relatively straightforward application submitted by Mr Martin Ray to add a public bridleway from Birdsley Farm to Portway Lane in the parish of Wigington, and was based purely on historical or documentary evidence. The matter rests wholly on the Wigington Enclosure Award of 1771 and is supported by two Ordnance Survey maps, the first dated 1834 and the second 1884. Members can see these at Appendix C. If members turn to the plan at Appendix B, it can be seen that the claimed route is relatively short and runs in an approximate east-west direction, linking the Wigington-Harleston Road to an existing bridleway. The plan clearly depicts the alleged route as a continuation of an existing public bridleway, or more specifically, public bridleway 15 Elford, and is demarcated in exactly the same way, although officers accept that this is not necessarily indicative of status. The plan is clear and complete, and the allotted field numbers are wholly visible and referred to in the transcript, and each supports the other. Turning to the transcript itself, we see that the award refers to a private wagon and drift road and public bridle road, and it is on this statement that the matter largely rests. It was not unusual for enclosure awards to refer to both public and private rights within the same paragraph, and the courts have held that the word public is taken to mean the same now as it did then. In this case, it is clear that the route had both public and private rights across it, and its private rights related more specifically to non-motor vehicles and cattle. Members will doubtless know that drift roads were typically used for the movement of cattle, enabling farmers and drovers to move their stock from field to field. Significantly, the alleged route is referred to as a public bridle road, and so there can be little doubt as to both its purpose and its status. It is clear, Mr. Chairman, this was a bridle road. However, the question has to be, does the route referred to in the enclosure award actually relate to the route that is the subject of the claim? And if we believe this is to be the case, then can it be said with any certainty? The route is described in the enclosure award as having public bridleway rights and is shown coming out of the road from Wigington to Harleston, and the claim route does indeed follow this line. There is, however, another route to the north of the claim route that also runs from the same road, albeit from a crossroad where 4 roads join. This road is also shown on the enclosure award and on both the Ordnance Survey plans. It even appears on the Finance Act plan. However, on scrutiny, it does not pass through plot number 52, which the claim route certainly does. The enclosure award describes the alleged route as passing through the allotment of Thomas Edgerton, number 52, into the road at the corner of Birdsley Lodge, and again this matches the line of the claim route. This is further confirmed by the route in the award continuing over the allotment of William Eagleston, number 58, to the Turnpike Road. As both the allotment of William Eagleston and the Turnpike Road are marked clearly on the plan, there can be little doubt that this is the line of the claim route. Interestingly, the enclosure award also gives a very specific description of the width, stating that it should remain as 30 feet in every part thereof. 30 feet is approximately 9 metres, and so exceeds the width necessary for a bridleway, although this is clarified somewhat by the transcript, stating that its use was also as a public bridle road and a public wagon road or drift road. In short, and by default, these measurements confirm that this is the route in question. Enclosure awards were much more detailed after 1801 and are often enough to prove a claim on the balance of probability. Earlier awards, such as the instant one from 1771, are less informative and on their own are more appropriately considered under the lower test of reasonable allegation. Turning to the Ordnance Survey plans supplied by the applicant, they do of course show the physical existence and line of the route, but offer nothing to us in the way of legal status. The 1834 plan shows the full extent of the route, and although it does join the highway at both ends, it is not shown to actually open into either. This detail could merely suggest a change in surface or that the claim route was not part of the public vehicular highway. Of course, we know this from the enclosure award, as it was also a private wagon road. Suffice to say that the OS plans merely show that a route was visible on the ground from pre-Victorian times in 1834 to the latter part of the 19th century in 1884. Turning to the landowner submissions received at all stages of the consultation process, members will note that the objections are not material ones or ones that can be considered by this tribunal of fact. If members could turn to the addendum, there can be seen submissions from several landowners, and the concerns identified relate to antisocial behaviour, namely off-roaders and 4x4 vehicles accessing the route, and the fact that the route is overgrown and currently impassable. Further issues relating to blind bends and local wildlife, including muntjac deer, behavioural issues, young adult males gathering in cars, playing loud music, and the use of recreational drugs, although again these matters are not that can be considered by this tribunal of fact. Taking everything together, therefore, your officers believe that there is sufficient evidence to reasonably allege that the route subsists and with the status of a public bridleway. In summation, your officers can do no more than to recommend that the application be accepted and that an order be made to add the route to the definitive map and statement for the district of Lichfield as a public bridleway. Your officers further recommend that the route should be to the minimum width of 2 metres throughout its length. Thank you, Mr. Chairman. Happy to take any questions.
Thank you, David. David, another David. Okay, so moving the recommendation, is that for both the acceptance that this is on the definitive map and also that it should be a minimum of 2 metres? Okay. All agreed? Okay, that's unanimous. Can I thank everyone this morning, officers and members, we've got a lot of important business done, There was over 1,000 pages for us to go through, so anyone who thinks this is an easy job, please come and read the 1,000 pages. And we have one final question from Paul.
Is Hannah all right? Just
Okay, so thank you, and we'll close the meeting at 11:35.